Hi. I just wanted to bring to your attention something that's just some side information that was provided by the folks at Visit Music City and CVC. On your desk, you'll have there some latest figures about the current hotel industry numbers. And I just wanted to make sure that you had that in front of you should you need that information. I've gotten some questions from constituents and beyond regarding just exactly how many hotel rooms do we have and how many are in the pipeline and whether or not that will affect or not affect your consideration on any short-term residential properties as well. So that is just presented to you guys so that you have it. Thank you.
Ladies and gentlemen, we're going to conduct this joint meeting by, like we normally do. We're going to proceed with the bill, get a second, give the sponsor a chance to explain, and then we're going to ask whether or not there are amendments, and I understand there are quite a few. And whether you're on codes or tourism and convention, you could go ahead and press your button. We're going to recognize you in that order. And if your council members just sitting in, you'd like to speak after the committee members speak, then you will certainly be welcome to speak. So having said that, we're going to go ahead with our first item. Our first item on the agenda is 2016-257, sponsors Sledge, Berkeley Allen, and other council members. And an ordinance amending section 16.04, 1110, section 6228.030 of the Metro Code law regarding the non-compliance with Title 16 and the penalties therefore. Is there a motion? Second.
Is there a motion from Conventions and Tourism?
Is there a second from Convention Tourism?
Yes.
All right. I forgot you were a double hat here.
Yeah.
Thank you. Okay. Sponsor Sledge. Mr. Sledge?
Thank you, Mr. Chair. I have an amendment that I wanted to move the amendment so we could discuss it.
All right. Is there a motion on the amendment? So moved. Second. Is there a motion from Tourism Convention? So moved. Is there a second? Okay. Mr. Sledge?
So we have discussed this bill in the Codes Committee at least, and we have an amendment. Chair Lady Allen and I had an amendment, and this is sort of the latest iteration that we hope reflects the desire of the committee as we understand it. So there are a few key parts of this. The first part stays the same of the bill, where we're talking about a stop work order to be issued for those short-term rentals that are operating without a permit. I think we were all square on that. When you didn't have a permit, that codes could issue a stop work order that would hopefully provide a more robust deterrent for these completely illegal STRPs. Now, the second change that we have here is what the amendment addresses. And so when you look at the at section 2(6)(b), when you're looking at upon a finding of the Board of Zoning Appeals. Currently, the Board of Zoning Appeals, when somebody comes to the Board of Zoning Appeals asking basically for grace, where they have operated a short-term rental without a permit and have a variety of reasons that they just were not aware that they were supposed to get a permit. The Board of Zoning Appeals right now is totally black and white. They say, if you are operating without a permit and you have come and turned yourself in and you want to get right with the law, well, too bad, you've got a year ban, plain and simple. It's all they're able to do within the law. What we are trying to do with this amendment is create that gray area and create that grace that I think the committee and that many of the short-term rental operators, both permitted and non, have asked for. What Council Lady Allen has done is addressed the sorts of evidence that can be used in making the decision, and the BZA making the decision to grant up to 1 year instead of a straight 1 year waiting period. This has the support of the Codes Department. It has the support of the BZA. In fact, I got reports from the BZA meeting last week that currently the board, when people are coming to, who are in this situation, they come to the board is telling them, you may want to wait. You may want to ask us to defer your appeal in order to see if this bill goes forward. Because the board has said, if you come to us today, we will have to give a 1-year waiting period, a 1-year ban. So the board is trying to telegraph basically that if we're able to give that grace period as a council, then they are willing to use that grace period as they see fit under these indications here. These indications, this evidence also indicates that they need to pay their taxes that are due. They need to basically get square with Metro Legal, and then they will be able to be considered to get that permit ahead of that 1-year time frame. So that is the grace period that the committee has asked. There's a 3-year section we can talk about in a minute, but I do want to see if there might be questions on that up to 1-year language,
Right.
Mr. Chair.
Let me go to Councillady Allen first, and she's co-sponsor on it, because you had an amendment too, and I want to make sure that we give you an opportunity.
Thank you. The only thing I would add is that we've worked together so that this is a single amendment. So everything that I have suggested has been incorporated into this one amendment.
Thank you.
So thank you.
Okay, question from tourism or codes committee members concerning the amendment? Okay. I don't know for what reason, Mr. Schulman, but you're not lighting up. Okay. There you go.
You got me?
I got you.
Okay, thank you, Mr. Chairman.
Absolutely.
Madam Chair. Question for the sponsors. $50 fine as imposed by a court of competent jurisdiction. Each day of operation without a permit shall constitute a separate offense. Is that just by the court? Does the Board of Zoning Appeals have any ability to assess a fine, or no?
Susan shaking her head no. And this language is the current language in the bill. We are restricted by state law, and I'm looking at Mr. Jameson to make sure I don't get this wrong. We are restricted by state law to a $50 fine per offense.
All right, so it's a $50 fine, but you can do it by each day of operation would constitute an offense. The second question is, it looks like, just looking through this, that you're giving the Board of Zoning Appeals the flexibility to do up to a 1-year waiting period, so they could actually, if they found certain circumstances, they could actually say zero days. Is that right?
That's correct.
Okay. And then I think, so let me make sure, the only group that would have that would have the authority to impose a 3-year waiting period would be if somebody went all the way up to a court of competent jurisdiction and made a finding. So if you went to the Board of Zoning Appeals, they could just do 0. But if somebody pursued it all the way up and the court of competent jurisdiction ruled on it, they could actually impose there shall be a waiting period of 3 years from the date of such finding. So does the court have any, would the court have jurisdiction, or would the court have any discretion in terms of what penalty they could impose?
Would you like legal counsel to answer that, Mike? Jim?
Sure.
Jameson?
Not under the proposed amendment. The court has 3 years, and it's not up to 1 year. It's not up to 2. It's not up to 3. It's 3 years.
So I guess one other question for the sponsor. Question is, why would you restrict the court of competent jurisdiction? It would be going up to, I guess it would go up to Chancery Court?
This was Susan Jones, Metropolitan Department of Law. This was contemplating tracking through the environmental court process.
Okay.
And in the event that the court were to issue an injunction that prohibited the person from operating, and upon their finding that the person had operated illegally, or then at that point, that's when the 3 years would trigger. That's really what that's contemplating. I think what you may also be thinking about is that there is an appeal right from the BZA also, and that's a writ of cert action to Chancery Court. But that would be tracking through a different method. And the BZA's decision would still have to go through the normal procedure in terms of appeal, arbitrary, capricious, or illegal. Is there any evidence, substantial material evidence in the record to support the BZA's decision? That would still be the standard. So we would probably, and I'm kind of speculating this one, but we would probably not argue or we would argue that the board could still not substitute its judgment for that of the BZA in terms of whether or not to go beyond, in your analogy, 0 or whatever the board's finding was. We're still going to be operating by that writ of cert standard. Does that clarify? So you really
Well,
kind of have.
I guess go back to the initial part, which would be environmental court.
Right.
How would you get there from? So if you're fighting over a violation, wouldn't you have to go to the Board of Zoning Appeals, or is there another route to get to the environmental court first?
If a person is operating and they're seeking that grace, or they have some extenuating circumstances that they want to get before the board in order to avail themselves of that particular remedy of being allowed to go ahead and operate, and perhaps getting less than a year to operate, a person could choose to do that. However, if the Codes Department decided that they wanted to move forward with prosecution of a case, then that case would go to environmental court, and that's how you would get to potentially the 3-year standard in terms of not being able to have a permit. Do you have anything to add, Mr. Cobb, on that piece?
Councilman, just as we pointed out that the Board of Zoning Appeals doesn't levy fines, the General Sessions Court doesn't issue permits, okay? So if it was adjudicated and a judgment was achieved at General Sessions Court, environmental court, then the department would be involved in any request in the 3 years subsequent to that of receiving a permit application and acting on it.
Okay, so it sounds like there's just two different ways of proceeding. If the Codes Department wanted to pursue some of their remedies, they might look at the court, environmental court. I guess the last question would be, it's a strict 3-year, though. If that's what they get, then it's a 3-year prohibition.
That's correct.
Okay. All right, thank you.
Thank you.
Mr. Chairman.
Are there any other questions on this amendment from any members of the Codes or Tourism? Okay, Holly?
I have a question for legal. So when we get to court, the judge basically says you're guilty or you're not guilty. And if you're guilty, 3 years is it. They have no leeway.
That's correct. The terminology says there shall be a waiting period. So upon a finding of environmental court referee or the judge of environmental court, you would have 3 years. Now, obviously, all of the General Sessions Court cases are appealable. You appeal from the referee to the judge of General Sessions, and then there's a right of appeal even from the judge of General Sessions to Circuit Court. So that would be the process. But as far as if he made that finding, that would have to be the ruling.
Okay, so I have a question for the sponsor. Why are we basically telling the judge what their option is? Why don't we let them decide?
Sure, it's a valid question. Here's the thought process behind it. Those who are going to BZA are going to be those who are under this framework. I don't think it's a supposition. This is what is happening. They are primarily, if not almost exclusively, owner-occupied residences in which there's no permit cap. So these are folks who didn't realize they had to get a permit, but are eligible for a permit if the BZA will allow them to be eligible. When you're going this route to environmental court, what these have been, and I don't know if legal or codes has the count on how many these have been, but these have been primarily, if not exclusively, non-owner occupied units where there is a cap. There is no relief for the person because the permit cap has been hit and they have just decided to operate illegally. They've decided to operate without a permit because they cannot get a permit. They have no route through BZA because that cap has been hit. So when they go to that route, what's been happening is they've been operating illegally, and they've been operating illegally with no recourse. And so the term I would use is you've got the worst offenders, basically. You've got the folks who are running the most outside of the law possible. If we're talking about the concern about 3 years, I'm happy to have that discussion. The reason I've put 3 years in here is because 1 year has not been a deterrent for these properties. They continue to multiply because the thought is by the time that I potentially get caught on this, I've made out with it. You know, I've made a net gain that's worth the risk. If it's 3 years, then the thought is that this is not a financially viable option for me to operate outside of the law, because if I do go through that process and a finding is against me, then that's it. So the thought is to create a deterrent for people to operate completely outside of the law.
Why wouldn't we leave it up to the jurisdiction of the judge to say you can't have a permit period?
You mean?
That of just 3 years. You see what I'm saying?
Well, they can't have a permit period. What I'm saying, I see what you're saying. You're saying if it opens up down the road. If that is I would offer this. If that is a sticking point, if it is a flexibility sticking point to say that it's 3 years instead of being up to 3 years, I think that's something I'm willing to discuss. But I do want to ensure that there is at least a deterrent from people starting down that path, that they know if I continue to operate outside the law like this, that I would be hit in a way that would make it no longer financially viable for me to do this. Because what's happening is the worst of the worst, they're getting funded, basically. They're getting mortgages, they're getting financed off of what they're able to bring in from a non-owner occupied short-term rental.
Okay, so I just want to make sure I understand this from legal. So they have the opportunity to go through the BZA first, and then after they go through the BZA, they can appeal it and then go to the court?
These cases can track two different ways. It can track administratively, or it can track through the judicial system. And so there is, administratively, it would go through the BZA, and they could come and they could make their case, and if the BZA finds that they are to be granted relief, the BZA can give them that relief. That decision of the BZA is appealable to court. It's appealable to Chancery Court on a writ of cert action. However, you have another way that these cases can also track, and they can track in an enforcement effort by the Codes Department through the Environmental Court. So it's really two separate tracks that these cases can go on. Does that clarify? Okay.
I just don't understand why are we saying 3 years in court and just not 1 year? Because by the time, and I understand where you're coming from, but by the time even a year, and they go to get their permit, they're going to all be gone. The non-owner occupied, I mean, majority of them are gone as it is in certain areas. So why are we pushing it for 3 years? That's my only concern.
Council Lady, I don't want to speak for the sponsors, but I think one of the intentions here was to increase the level at which non-compliant operators are, quote, turning themselves in. And if they understand that they're subject to a far less stringent penalty if they go to the BZA and seek redress there, rather than waiting to be prosecuted, I'm looking at the sponsors to make sure that was the underlying intent, but I think it was.
We're trying to get people into the correct pipeline, I guess you would say. And what ideally we would get them into is the BZA, so that they have some chance of redress and that they can potentially get back on the list if there's a possibility for that. There are some operators that, quite frankly, it's not worth their time and finances to go through BZA, because they know that BZA will fine against them because there's no permits available, right? So instead of going through the pipeline, they just continue to operate outside the system entirely. And that's the problem that we're having in many of our urban core districts, is people are operating out of the system entirely, and there's no chance of getting them in without some sort of judicial system action.
And if I could add to that, also, another way that people end up that way is that Metro sends them an abate notice, and they choose to ignore that. So they've been told once by Metro Authority, you're supposed to have a permit and you need to stop. I think the examples that we're looking at now that have gone as far as environmental court have gotten there because they deliberately chose to ignore the abate notice from codes. And so those are the egregious cases that seem to be subject to a much higher standard than the ones who just innocently didn't realize that they were supposed to have a permit and then went to try to get a permit. Some of these people have never tried to get a permit. They just thought see what happens, you know.
So they really have to have an abate notice first.
I mean,
Could
what
go
I'm understanding
this
is the
route.
ones that have gone to environmental court have gone there because they ignored an abate notice.
Yeah, they get a warrant put out against them.
Okay, thank you. Councilman Rosenberg.
Thank you, Chairman. Two basic questions. The first one for the sponsor. Councilman, is it fair to say that the idea here is to lessen the penalties on your garden variety offender and make it more severe for what we're now calling the worst of the worst?
Yes, that's correct. We're trying to help the people who want to get in line with the codes that we currently have, but have found themselves outside of it. And yes, the intent is to really say there is the worst of the worst offenders, and that would be appropriate.
Okay, thank you. And Councilwoman Huezo, if you don't mind, you have legitimate concerns. Are they that this is too severe, or are you afraid that people who aren't the worst of the worst might get caught up in it?
The second part.
Thank you.
Council Lady Hurt.
Oh, Mike.
Okay, your question was, okay, thank you. Okay, are there any other questions from, question has been called, all in favor of calling the question? All opposed? All right, we ready to vote? Ready to vote on 2016-257? As amended?
We have to do the amendment. Approve the amendment.
Yeah, we have to approve the amendment first. So we're voting on the amendment. All in favor of the amendment that was offered? Let it be known as aye. All opposed? Let the record indicate the Codes Committee voted 5-4, none against for the amendment.
All those in favor for the amendment on the Conventions and Tourism Committee, say aye. Aye. Opposed? You? You're opposed? Duly noted.
Okay, we'll go back to the bill itself as amended. All in favor of 257 as amended, let it be known as aye. Let it be known as aye. All opposed? No. Let the record indicate 4-4, 1 against on the bill as amended.
On Conventions and Tourism Committee, all those in favor? Opposed? All right. It's causing trouble. Four and one on both for Conventions and Tourism.
Record indicate 4-4, 1 against, Convention and Tourism. Okay, next we'll move to 2016-373, sponsors Mendez, Sledge, and other council members. An ordinance to amend 6.28 of the Metropolitan Code pertaining to short-term rental property. Is there a motion? Second. Is there a second? Okay.
Conventions and Tourism. Do you have a motion?
All right. The bill has been motioned and second. Now we're ready for discussion. Well, first of all, do you have an amendment? This is your only amendment? No further amendments? Okay. All right, Mr. Sponsor. Got you. You're on.
Thank you, Mr. Chair, Madam Chair. So this one is pretty straightforward. It's very short. It's got one small thing. It makes it so that permit holders would be required to put their permit number in any online advertisement for a short-term rental property. The goal here is to make enforcement easier. It adds almost nothing to the difficulty of anybody who operates one of these. It's just a couple seconds online to stick the permit number in the advertisement to hopefully make it easier for codes to enforce. So I appreciate the committee's hearing this and considering passing this on second reading.
Are there any questions for the sponsor? Any questions from Tourism and Convention? Are we ready for the vote? The Codes Committee, all in favor? Let it be known as aye. Aye. All opposed? Let the record indicate Codes Committee voted 5-4, none against.
Convention and Tourism, all those in favor? All those opposed?
Let the record indicate Tourism Convention voted 5-4, none against. Next, we want to move on to 2016-374, sponsors Mendez, Sledge, and others. An ordinance to amend Chapter 6.20, an ordinance to amend Chapter 6.28 of the Metropolitan Code pertaining to short-term rental properties, in parentheses, STRP. Is there a motion? There's a second.
No, yes, is there a motion? Is there a second? All right.
All right, discussion.
Thank you, chairs. So this is another one that I think is relatively straightforward to make enforcement easier by codes. It would make 2 changes to the application process. One, the application would now be under oath. So the applicant would be swearing that the contents of the application are true. And then the second thing, it would add to the application a statement that if the unit is subject to a homeowners association or condominium rules, the applicant would be verifying that the rules for the condo or the homeowners association allows short-term rental properties. This has been, in talking to codes, one area where they've had a hard time with enforcement because it ends up being a multi-family condo development, and the complaining party will say this is against the rules, and then codes doesn't really have any way to look into this. So again, it's meant to be a rifle shot, simple change to make enforcement easier. Appreciate the committee's attention and would request passage on second reading.
All right, committee members, discussion.
I have a question for codes. Don't we currently have like an affidavit that has to be signed and notarized or something and sent in, and that's basically their oath?
Oh, sorry about that.
All of our permits dealt with permit applications where the applicant signs the application stating that they swear that the information's true and accurate, and if misrepresented, it's grounds for revocation and such. This takes it to where, as I perceive it, it's a separate document, a separate affidavit type document would be signed in front of a notary. It would have many of the same statements, but it would contain an additional statement where the applicant would be swearing that it also does not violate any HOA agreements, condominium bylaws, those types of things, restrictive covenants. A lot of things we don't enforce, but neighboring property owners certainly can and do.
So the affidavit that they sign now, that's the renewal affidavit?
I'm sorry?
There's some kind of affidavit on Code's website for the...
There's an application that says, I hereby apply for this permit, and there's statements on the face of the permit that I swear that the information contained in my application is true and correct, and I'm the proper person, and I have authority to make application for the permit described here under that type of language. It talks, there's some boilerplate language that's typical in about all the building permits you'll see, whether it's in Nashville, Tennessee, or, you know, it's in Portland, Maine, or it's in Chicago, wherever the same boilerplate language is typical in permit applications.
So all we're doing is taking it off the application and making it a separate document, adding the HOA, and then they have to have it
Putting an
noted.
additional document. We're still going to have the same boilerplate language on the permit application. This also adds an affidavit which requires signature in front of a notary public. Okay?
Do you have any more questions, Council Lady? Okay. Any more questions from members of the committee, either tourism, convention? But before we call the question, Mr. Cobb, let's talk about the duplication in process. That's the one thing that I hear. It seemed as though we have a process in place, and this is requiring a person to take another step going before a notary, which we know a notary just says you're the person in front of them and do not necessarily be able to tell whether or not the contents of a document is true on its face.
Councilman, if I could jump in just for a second. The impact of the notary verification is that it becomes an official oath. The application now is not an oath. You can't prosecute for perjury if they're wrong or intentionally misstate. The notary is a significant step, and they could be prosecuted for misleading for perjury because they are swearing to an officer of the court, which is what a notary is.
That makes a difference. Okay. Any other council members? Councilman Hastings, do I see you with your button? Okay, let me find you here.
Thank you,
Councilman
Mr. Chair. I really appreciate it. I just wanted to just piggy on this issue into one area where I really feel personally any area of follow-up that we could do with the codes department or any other department that we have here with Metro to help with the system. To make sure that we're following through with the things that are being set up for all of our constituents here in the city. We need to do that. We find it, I know all of us have some sense of guidelines that have been put into place by the government, and a lot of people don't necessarily follow those things. My only question is for codes and also other entities that are working on this language, is that when this goes through, are we going to have the might and the force, and also, because I know codes is stretched, are we going to have the follow through to actually mandate these laws and the things that we have in place?
Okay. Mr. Cobbs, I guess this question is for you, sir.
Enforcement question.
It's a question of enforcement, whether or not we would have the inspectors and the resources to have enforcement on this type of procedure.
Well, it's a violation. It's a code assigned to us for prosecution. And we've actually prosecuted cases, and we've had pretty good success rates in environmental court. I think the greatest challenge is you have to identify them and locate them if they're outside of the permitting process. And you've got to gain evidence that they have violated the law. And then you've got to issue a warrant. In other words, we can't be prosecutor, judge, and jury. We prosecute the case to get it on the docket before environmental court. So.
My question is directly to that. Do we actually have the manpower to deal with that right now on this sector? Because there's other code issues, I know mainly within my district, and I can only speak for the people that I represent, that there are code issues, and we're having a lot of follow-up through, and I know I am constantly in communication with a lot of the representatives that we have. I really feel that this process is needed with the system that we're talking about today, but I also want to be for sure that we're just not adding another title or another verbiage just to the staff members that you have when they're not able to do all the things that they have to do right now.
Okay, well, we've already adopted the short-term rental property ordinance. It already is law. It's already assigned to the department. So I don't see anything that has been discussed thus far tonight to represent any additional burden, I guess, for the lack of a better term, on the department's time.
Just directly, let me just go here. On a timeline of us just filling in the blanks of getting the things that we need for our communities and the follow through within our districts and our areas here in Nashville, are we able to handle, and I understand that has been put onto the docket of your responsibility, with the current guys that we have right now, the men and women that we have right now, are we able to follow through and to make sure that these things are handled along with everything else, and we can get all of these situations handled within our communities?
In my opinion, yes. We are evaluating where we are in a lot of areas of the department in terms of staffing and manpower. But to a great extent, depends on who asks and what their thought process is and what level of enforcement they desire. But the question is almost like the question, how long's a string? It depends on what is desired. We tend to deal with what is. Based on what is the current workload, I think the number of cases assigned per inspector, the number of inspections assigned per inspector, the number of cases that we're prosecuting in court are within normal ranges. So to that extent, yes, but we're constantly evaluating that. The council this year approved some additional staffing in the property standards area and in the zoning examination area, both of which are dealing with the short-term rental property ordinance. Previous years, the council's been good about giving additional staffing in zoning, in plan review, in building construction inspections. But we're still evaluating that, and we'll further evaluate it and give you a report or request prior to the year's end. Okay?
All right. Thank you very much. I just wanted to make a statement concerning that, and that is not to stump on any one particular department, because I know here in Metro government we are almost to the extent of being overworked, and I definitely understand that. But I can say this, is that there's a lot of things that are within our communities right now that are not being dealt with the departments that we have.
Right.
And we need to make sure that we take care of all things and make sure those things are being dealt with. Thank you.
Point well noted, Councilman. And Mr. Cobbs and the Codes Committee have been in conversation. He'll be back before the Codes Committee and the council to address any issues that we may have along the areas of inspection. So that point is well taken, and when that time come back around, you have an opportunity to ask the same question. Thank you. Are there any other questions from Tourism, Convention, or the Codes Committee? Question has been called. All for the call of the question, let it be known as aye. All opposed? All right, we're ready for the vote.
Wait, yeah, go ahead. Sorry.
You ready?
Yes, I was
All right.
confused.
All in favor? Bill 374, Codes Committee, let it be known as aye. All opposed? Let the record indicate 4-4, none against.
I'll let the record show that Councilwoman Mary Carolyn Roberts is abstaining from this vote. Do I have a motion from this committee? Do I have a second? All those in favor? Opposed?
All right, last bill of the evening, 2016-375, sponsors Mendez and Sledge. An ordinance to amend Chapter 6.28 of the Metropolitan Code pertaining to the maximum occupancy of short-term rental property. Is there a motion? So moved. Second.
Our committee, is there a motion? So moved. Second? Second. Okay.
Mr. Sponsor.
At the request of myself and my co-sponsor, we'd like a one-meeting deferral on this bill.
The request is for a one-meeting deferral. All Codes Committee members voting yes, let it be known as aye. Aye. All opposed? Let the record indicate 4-4, none against, for a one-meeting deferral.
Conventions and Tourism, all those in favor? Aye. All those opposed? All right. Similar in 5 and 0 against.
You get one abstaining?
No, not on the deferral.
Okay. Okay, members of the Codes Committee, Tourism and Convention, that's it, and this meeting is adjourned. Thank you.